We're on the record, Your Honor.
Good afternoon. In the matter of Norcutt v. Council. Case D16-537499D. Please go ahead and turn on your cameras. Mr. Counsel?
Yes, ma'am. I apologize.
You able to turn your camera on, sir?
Yes, ma'am. I'm trying to get it to activate. Can you see me?
I can, thank you. My apologies for being late. I
Awesome.
was in another meeting. Ooh. So we are here for the well, I believe you tell me why you think we're here. I mean, I'll see if it comports with my understanding as well, because the notes that are in Odyssey I don't understand. So, Mr. Page.
Well, Your Honor, I'm the one that filed the paperwork originally back. The reason why we're here is because I filed the motion
for this
against.
hearing, for this hearing today. What's the purpose of?
Well, yeah, the purpose of this hearing today is because I filed everything. I started the whole process with the other party, and the other party is completely alienated me from my child, and like all she's worried about is money.
No, that's not what I mean, Mr. Page.
Indulgence.
Wait,
we're getting an error message with the blue jeans.
Okay, we're having technical problems. I don't even know if we're recording right now, so stand by. What is that noise? Mr. Counsel, are you screen sharing here?
Right.
No, ma'am.
Or is that Goldie? Miss Goldie that's trying to screen share?
Is Ms. Norcutt present?
She was, but she just left.
Okay.
My apologies.
Oh wait,
Okay,
there she is.
back.
Ms. Norcutt, are you able to turn on your camera?
She's muted. And
There she is.
Okay.
Okay, thank you. And we're recording?
We are recording.
All right, I think we can proceed. What I have here, I have that we're here today for the continued decision hearing, where I'm going to give my decision, but it also says Dad's response to the 3 documents filed by Attorney Page by August 6, 2021, and Attorney Page's updated child support arrears. So, we talked about, Mr. Page, we talked about the child support arrears chart that you had prepared, and that how it still had the ability, it computed penalties after February 1st of 2020, and the law changed with respect to child support arrearages having penalties. And you were going to prepare a new one, and I don't see it. Are you speaking, Mr. Page? If you are, I can't hear you.
Sorry, I didn't prepare it as attached. Let's see. We had the hearing on July 14. On July 21, I submitted updated schedule of arrears for two parts. One part was the plaintiff's declaration in support of child support arrears for Gage. The declaration was signed by my client, and then it provided the amount which is owed, which was $5,849.95 as of July 22. We took out any calculations for penalties after February 2020, so that stopped accruing after that point. Then, as far as Gavin's educational account, we submitted the schedule of arrears for that on July 21 as well. That figure came out to be one moment. That schedule came out to be $1,264.36 as of July 22, 2021. And again, that was something where it stopped accruing penalties after February 2020.
Under what basis would there be an allocation of penalties to the amounts due for the payments of the 509, the account payments?
In order to get this through with as little trouble as possible, we characterized the educational payments as being child support because he was obligated to pay something for Gavin, and that would be the least resistant way to do that. Gavin aged out in about June of 2019, so even though he was ordered to pay much, much more in monies to his educational account, we cut it off then because that's when he aged out. That is how we got to the figure of $1,264.36 as of July 22.
I don't have whatever document it is that you're looking at. What I have is plaintiff's. Oh, I see. You filed something on 7/21.
Right, you give us a week or so to get the penalties taken out or corrected, which we did, and then we went ahead and filed.
Okay. No. I'm looking at the wrong ones, and I didn't realize that you did provide that, and I was, I've been looking at the wrong thing. 628. Shoot, I thought I was ready. Yeah.
You know, can I ask to push this out?
No.
If you haven't been able to.
What do you mean by push this out, sir?
If you haven't been able to read the documents, or if you haven't been provided the right ones, I'm confused.
Yeah, I didn't.
And
I didn't think anything else
I
was
don't.
filed here. And it
Yeah.
I thought when I was looking at these documents that have been filed, I was thinking that those were filed, that those were the same ones that had previously been filed. I didn't realize that those are new documents. So what do you mean by push it out? I mean, like, I can look at these and be ready in an hour.
Yeah, I have therapy with my mother. I'm caring for her right now. So I do have a schedule throughout the day. If it's going to be another hour, I won't be available the remainder of the afternoon. So that's why I was asking if you need to review that. Can we please push this out?
One, Mr. Counsel knew that this was scheduled, so he had a duty to block out his day. Two, did your Honor's experience, this is not your first case, you can do this in probably 10 minutes as far as reviewing and analyzing the documents.
I wasn't asking you, Mr. Page.
Well,
I was respectfully asking the judge.
Please be respectful, Mr. Counsel.
I do believe I could take a look at this. I was just erring on the side of caution by saying an hour. But
Understood.
all right, let me go off.
I also did, and I did file a few things as well for your,
I don't know
for
what
you
else
too.
I don't know what else is there. I've not looked to see what. I mean, I did look, but I don't know what I was thinking. I thought that these were all the documents that were previously filed, not new stuff. Oh, since that hearing. So I don't know.
Again, that's why if you needed further time, I would respectfully request that.
17.
Just because, I mean, for due fact is this.
Well, let me see if I can get you back in here right away. I don't want you to have to wait anymore. You've waited long enough. My goodness.
Well, absolutely. And I would like for you to have an opportunity to review the harassment, the medical records, and stuff that I submitted.
Well, I'm not sure any of that's relevant for today, but
And very, very relevant, Your Honor.
well,
Extremely relevant.
well, I know it's relevant to you. I didn't mean to be disrespectful. However, I meant relevant for the limited scope that we attended hearing. I can tell you that I have now, I brought myself up to speed on the first 3 days of trial that were heard by Judge Moss. On day 1 was November 19th, 2019. Day 2 was January 23rd, 2020. Day 3 was February 28th, 2020. And all 3 of those hearing dates were heard by Judge Moss, so I was not there, obviously. But I have reviewed Judge Moss's notes that she provided to me, as well as informal transcripts of all 3 days of hearing. So I have,
Including the witnesses?
I'm sorry?
I'm sorry, including the witnesses' testimony?
I read about all of that, but all of that testimony was not relevant for the purposes of our limited scope today. Our limited scope,
Understood.
Our limited scope were the following orders, and I wrote this on that big chart. Was number 1, defendant sought an offset for child support arrears in the approximate amount of $2,000. Thus, mom would pay dad $4,000, or in the alternative, mom would pay dad approximately $6,000 pursuant to the provision in the decree of divorce. So that was issue number 1. Issue number 2, temporary reduction in child support. And issue number 3, attorney's fees. And then plaintiff sought the following orders. Number 1, order to show cause regarding dad's failure to pay the 509 payments. Number 2, to modify, that is to increase the child support retroactively to August 2018. And item number 3 was attorney's fees. Those are the only issues that are remaining after Mr. Counsel stipulated to the custodial arrangement that exists right now. At the beginning of day 4 of the hearing, when you appeared in front of me on June 16, 2021, one of the first things that you said, Mr. Counsel, was that you are not contesting the child custody aspect of this at this time. So therefore, that was off the table, and I would say approximately 99% of the first 3 days of the evidentiary hearing were focused on that. I read
Correct.
all of that, and
Thank you.
I've highlighted in my notes and in the transcripts the only testimony that was relevant to the issues that are currently pending before the court, and I just went over those issues, and there's very little from the first 3 days, but I have reviewed it, and I do know about the testimony that was given in the first 3 days of the trial. So, what my problem is right now is I have not reviewed the documents that were filed between the last court hearing, or I should say, not the last court hearing, but it looks like June 16th or June 9th till now. That is what I need to review. Yes, June 16th. Was it June 16th?
July 14.
July 14th. You're correct. July 14th. So
Correct.
that's the only thing that I need to review now. And I don't know how much of it is. Let's go off the record. I mean, I don't want you to just have to sit there, but I also don't want you to have to bring you back. So,
Understood. Well, that's the reason why I answered the way I did when you asked me why we were here. Has none of this would be any issues if the plaintiff would have followed the court orders in the beginning. Well,
It's not really argument time for Mr. Norcutt or Mr. Counsel, so either he stops talking or he gets put on mute.
Well, I'll make that determination, Mr. Page, but I actually do agree with you. So I'm not going to re-argue any of this. So I want to go off the record. Give me some time to review this so you don't have to come back. And I'll call you back here shortly. So just go ahead and go about your business. If you're not ready when I'm ready, we'll call your offices respectfully. Mr. Counsel, what's the best number to be able to reach you?
702-336-1089.
All right, very good. And the court has Mr. Page's number, so we'll get back in touch with you so you can log off, but we'll call you shortly.
If you want, I can just mute myself, and then I'll leave the speaker on, and when you're ready to go, you just say something.
All right,
And
that's what I would
mute
always
myself.
do when I was in your shoes. Okay, that's fine. Whatever you're most comfortable with, Mr. Page. If you need to sign off, go ahead and do so. But just give me a little bit of time here.